everybody. Yeah, it's spring break. Hopefully it's spring. It might be spring break where you are. If it is, we hope you have a good spring break. Thank you to Kyle and all of our friends at Noble People. Great discussion had there for sure. And this is another great discussion that we want to have. So the whole thing about indie agency news is we're here to serve our members, and that's incredibly important. And so every member is going to have a different problem or issue that rises up to the top. So for a lot of us, it's biz dev. For some of us, operations might go to the top. Maybe it's talent. Maybe it's all these other things. The one thing that is always in there is legal. Is legal. And the creative service business is very, very different in that it is such a unique beast. And there are so many moving parts. And things have changed so dramatically, even in the past few years. I'm very lucky to have Matchstick Legal here in Portland as our attorney. And we're very grateful that they are members as well. So reminder that you saw the disclaimer at the beginning. So remember that disclaimer is in full effect before I bring on our wonderful partner, Jen Becker, partner at Matchstick Legal. We're going to talk about something very, very specific here in a moment. But Jen, I want you to give a little bit of the background of the firm and how you even got into this business in the first place, like how you gravitated towards all this.
Yeah, thanks for the intro, Doug. I think there's a lot of business attorneys, and there's a lot of attorneys who kind of touch creative and digital firms. And so we decided that would be a really great industry to specialize in. And we saw the need for it. And so myself and my two partners, Josh and Gabe, I've been doing this for about 15 years. Josh is going upwards of 20, same with Gabe, I think. So I think we just saw a need for it, and we like to work with you guys. It's a fun group of folks. Personally, I'm not super creative, but I think by working with our clientele, I get a big creative adjacent. And so it's kind of fun in that piece to see what people do with their craft and their skill set. And we get to help manage the legal bits, get that off folks' desks so they can focus on the stuff that they enjoy and why they went into business. So it's a great place to be. And the industry's changed a lot just in the past 10, 15 years since I've been working in it as well.
Oh, absolutely. So your, I guess, jurisdiction, for lack of a better term, explain to us how how it works. So if you're an agency in Florida, it's like, oh, I really need counsel. How does that all work?
Yeah, for sure. So we actually work with agencies all over the country. We even have some clients up in Canada and the UK. We worked with folks a little bit in Europe as well. But I would say we have agency clients in almost all 50 states. And that's because contract law is pretty much the same across all the states. Different things are going to vary. Like if you have some employment issues, we advise on those pieces. If things get super sticky and you've got a discrimination case in New York, we're going to have to refer you out to someone who's boots on the ground there who specializes in employment law. But as far as advising on contracts and negotiations, service agreements, statements of work, we've got you covered pretty much all across the US.
Well, and that's a good segue. You're like, I mean, there's a professional segue right there. So very recently you came to me and said, hey, heads up, we've got this report card where we review and rate an agency's MSA and SOW, so master services agreement and scope of work, and more than 50 criteria across 9 different categories. Then you get a report outlining what you liked, what concerned us, and where you can improve. So this is obviously a no obligation thing. And you've been doing this for, again, you've mentioned that you've been in this business for a long time, but this report card is really interesting because you've been doing this for a while, and you and I talk about this all the time, how quickly things are changing. So if you had a master services agreement from 5 years ago, chances are you got to know what's going on there. So walk us through the thinking of why you wanted to build this report card in the first place.
Yeah, absolutely. So we have We started this, I think, even pre-pandemic. We've been doing this for probably 7 or 8 years. It's just a great diagnostic tool
Right.
for our agency clients and folks who might want to work with Matchstick, or people who just want to be like, how does my contract level up? Is it fantastic? Is it horrible?
Right.
People kind of cobble together an agreement. Maybe they have other friends who are founders and own agencies. Maybe they've
Right.
pulled somebody else's agreement, or they put some together on the internet. They had another attorney draft it for them, and it might just be like a general consulting agreement as opposed to specific for the industry. And so what we want to do is just, it's a free service. We review the agreement and kind of let you know if you have all the highlights. And like you mentioned, there's 50 different things we'll go through. There's kind of
So
some big categories like,
my
is it well written? Is the communication piece there?
Right.
Like the important stuff, invoicing, termination clause. Are you appropriately protected with your indemnifications and the cap on liability? So kind of all the biggies. And then we also get to the nitty gritty and
Right.
kind of like let the client know if you're missing some important pieces. Your agreement might not be broken, but it could also be more user friendly. And so it could be easier for you to understand it, easier for your clients to understand it.
I was just going to say
Yep.
one of the biggest things that stood out to me was when we first started working together. You said, "Do you want this to be super nerdy?" Like you had these different scales because you're right. If you are a, a design agency that has a certain point of view, personality, you can still accomplish the legal necessities, but it doesn't have to be in a wrapper that feels like gargling broken glass.
Absolutely. And your contract is a reflection of your agency, right? It's
Right.
your communication piece. Your clients get it, they see it. If it's super dense, hard to understand, they have a bunch of questions, that doesn't reflect well on you. I mean, you can blame it on your attorney, but if it is pretty and it reflects your voice and it's got a good vibe, and it's like sometimes people go for like a chatty contract.
Right.
And you can get that across without having a bunch of legalisms. You don't have to say whereas and Latin
Right.
terms. You can still be protected and have it be very plain, simple English.
All right. Yeah. So you and I found a middle ground for our stuff.
Mhm.
Yeah.
Yes, I think it was informal or business casual, I think is where we
But
landed for your stuff.
yeah, I know. And looking at the way I'm dressed today, maybe I should have gone for even more casual.
Yeah,
And again, understanding that this is a general statement, not legal advice, anything of that nature. Where are agencies, in your estimation, falling short? And is this a situation of the agency hasn't updated their MSA or SOW, or where are some of the gaps right now that you're seeing that are really important for agencies and indies in particular to be taking a closer look at?
yeah, I think a lot of places where we see people could use some more protection, honestly, with the economy, that's a whole nother conversation. But with the payment terms right now, I think things have
Right.
changed a lot in the past 5 years. And so, in addition to some intellectual property pieces we can talk about in a bit, I would say making sure that your payment terms reflect your business. So get as much money upfront as possible. Maybe consider some retainer pieces. Make things non-refundable. Make sure you're protected if things go south, because I think there's been a lot of that recently. And so making sure you have those appropriate protections in your agreement, to get paid as much as you can and as soon as possible. And then also, some things we've been noticing with our clients is if their projects get backburnered and kind of they
Oh,
don't, there's not communication pieces, the key
mm,
stakeholders they're working with are just not responsive, funding might fall through. So kind of giving yourself protections if the client's not meeting their obligations, where you can stop work, where you can pause work, you can make them execute a new SOW with some different terms. Now that you figured out that client might be a bit of a pain in the ass to work with.
sure.
So kind of protecting you if things don't go according to plan, those worst case scenario provisions.
And I think that an agency is effectively, I mean, we're talking about a service business, right? We're talking about a
Yep.
service-based business. However, it is very different. It is very unique. And it is not a business that necessarily has the largest margins in the world. So, though, I guess where I'm going with this is number one, yes, absolutely protect yourself. And I suppose part of this too is if you're an agency and a client or a potential client goes in and starts redlining things and saying, "Well, these payment terms don't work." That's a hard thing to balance. But at the same time, you're right. Those protections more than ever now, because 10 years ago, 15 years ago, it was different. but now there's so many like little angles that are out there and all these little nuances that people might not necessarily know about. And if somebody comes in and starts redlining and saying, "Oh no, we're going to pay you in 4,020 days as opposed to 30," I'm just I don't know if there's really a question in this, but it's an observation that there are a lot of things that have changed that are really important for agencies to understand. You brought up the payment piece of it, and that is such a sticking point.
Absolutely. When you I like, I tell all my clients that you're not a bank. You are not a bank. You're not gonna float the loan for your client to pay you in
Right.
90 days, 120 days. I think I saw a contract the other day that was like 160.
Oh God.
And sometimes like you need the work and you need the
Sure.
project, you need to pay your people, you need to get your stuff taken care of. I think in those cases, you can let your clients know that you'll agree to that, but it's going to be a different price point. So you're taking on so much more risk by
Right.
agreeing to those payment terms that it's going to cost them more money, or there's going to be more upfront, or there's different ways to manage it, or maybe you get portfolio rights that you didn't necessarily have in the contract to begin with. There's
Right.
some other negotiation tools there. If they're really sticklers for the payment terms, you can push back and say, well, it's going to cost you either with fees or with some other protections that we want instead.
Yeah, and that's not an unreasonable ask.
Yep.
And being half Italian, I like a little vig. I like a little extra, a little vig
A
on the
little
top of
extra
that.
something, something.
A little vigorish, they call it. It's called the
Hmm.
vig.
Hmm.
Um, the portfolio piece of this is really interesting. Um, uh, being because and here and it gets frustrating. It gets really frustrating because if you're an agency, you're number one, you're really proud of the work, and then a brand or a client turns around and says, "Yeah, but the world can't know that you did this.
Yep.
You can't promote this." I'm curious to understand how to navigate that. And again, understanding this is not legal advice, but this is really talking about your experiences and how agencies have navigated that, because that portfolio piece or being able to go out and do PR around the work that you're really proud of, that helps grow a business. So I'm curious what that landscape looks like right now and how that would fit in to these agreements as well.
Yeah, so we definitely, part of the report card is review to make sure there is a portfolio clause in there. And ideally, if it's your agreement, you're saying that you can use it as soon as the deliverables go public. So as soon as it's out there in the world, you can showcase your work, whether it's case studies, screenshots of the website you produced, kind of explaining stuff on social media in your channels. If you're doing awards, wrapping things up in a nice way to show the work that you've done, basically presenting it and showcasing it any way you want to. And so that should be in your agreement, and it shouldn't be conditioned on the client's prior approval. But like Doug, like you were saying, a lot of clients are now pushing back on that and saying you can't do it unless we say you can do it. And oftentimes it's in a usage situation where each individual usage has to get approved.
Oh,
For
sure.
example, if you're working with Nike and Adidas, they want to like see every single thing you do before you put it out there.
Sure. Sure.
um, um, so I think in those situations, you can have language in the contract saying, with prior approval, we get to do X, Y, and Z. And I often advise my clients to talk with their business contact during the negotiation, say, well, what does your portfolio rights approval look like? Who do we talk to? How quickly is it approved? Is this a
Right.
pretty regular process, or do they like shut everything down and say you can't tell the world, like you mentioned, that you're working with us? And if they completely shut it down, then you can say, well, our price point for this project was based on typical portfolio rights that we get to showcase it and show it to the world once it's
Right.
public. So since you're not letting us do that, it's now 10%, 20% more. So
The
kind of
vig.
lean on the finances where you can.
Love the vig.
Yep.
And I think the other thing to point out too is making that portfolio piece not an oh by the way. And what I mean by that is you get so caught up in the minutia of getting a lot of the stuff done. And then, oh, by the way, we got to think about portfolio. And then you've done all this work and you presume that you're going to be able to share this work. And then you get the Heisman. And that is, and I've seen that happen before, and it's deflating. It's really, really deflating.
Mhm. But it's
And
and how you like get your business too, right? That's how you fill your pipeline. So
that's
not only do you not get to show it off, but it doesn't help you
right.
get more business, help you keep going.
Exactly. Let's talk a little bit about IP and how that has changed over time. And we're not going to go into the wormhole of AI, et cetera, et cetera. I'm more interested in uh, let's do it in 5-year chunks. So 5 years ago, 10 years ago, 15 years ago, the main differences in IP rights and how that would fit into an agreement like this.
Yeah, for sure. So I think a while ago, a lot of people just did a work for hire structure where the moment you create it, the moment your client gets it. So like they pay you to do it, and the moment that you create the thing and put it into the world, then they're going to own it. And what's more beneficial for folks in the creative space is an assignment structure. And so your client gets the work, but only when they pay you. So again, it's this payment trigger that we've been talking about, kind of a thread to this whole conversation.
Mhm.
And that's what we look in the report card too, as well, to make sure you're protected with that, so that the client gets the work, but only after they pay you for the work. And so that's the additional protection that we're really recommending now with the IP piece.
What's been the biggest change that you've seen, and just in general? Because it felt, I mean, let's go Napster days. It still felt kind of
Mhm.
Wild West, but now now the technology is such where, I mean, you take a look at something like YouTube, where it's able to, it's able to see, where the copyright might, if there's a piece of music that's not licensed, or et cetera, et cetera. What are some of the biggest changes, and what are some of the biggest lookouts for agencies around IP, like the things they should just like not even touch with a 40-foot pole?
Like we don't want to talk about AI, so we're not going to
And we're
delve
not
into
going
that.
to AI. That's a
That's a
totally
whole other
different. That's
conversation.
a whole. Yeah.
Yeah, I think probably with a lot of what your clients touch is making sure that there's a differentiation between, like you mentioned, where things are licensed in the right way. So if you're using third-party materials with your deliverables, making sure that you have the right license rights for that, but also that your client agrees to abide by those license rights. So it's not up to you to make sure that the client agrees to the terms of
Right.
some fantastic illustration that you're putting in a website. Like you're going to tell them what it is, and they have to abide by those terms. So kind of taking the risk off of you as the ultimate creator and just passing along those third-party licenses. That's a nice way to protect yourself as well.
Right. I guess one of the messages too is, and this is what's I think really great about this report card, is reminding agencies that you have much more, power's not the right word, but you know where I'm going with this, which is,
Yeah, know your
you know,
value.
that's exactly right. And I feel like that we're reaching a stage where, and to the point that is, it's very real. We would love to have a client. We would love to have a new client. It's cool. And yes, and you've outlined several ways to protect, but how do you advise an agency to get into that mindset? Because it's very easy for an agency that may have been doing something the same way for a very long time, and it may not have been comfortable, but at least it got the job done. What it feels like, you just said value, and leaving so much, s- not understanding how much you might be leaving on the table. How do you advise clients to get out of that habit of, well, we won't get the business if we do it this way?
Yeah, I mean, change is hard, 100%. I'm not good with change. You got to have a growth mindset for all that
Right.
stuff. But I think
Right.
recognizing the value of your services that you provide. And if you're redlining, if you're negotiating with a contract and a client at that point in time, like you're in the door, right? They like your services. You might have been working with them. You might have done a discovery phase. You answered an RFP. There's a reason why they're continuing to work with you. And so if you're redlining an agreement, signs are pretty good that it's not going to fall apart in the negotiation process. And if it does, then things aren't going well with your attorney
Right.
because you want to get the deal done. So I think recognizing that at that point in time that you have value, your clients want to work with you, and kind of, I would say, stick to your guns.
Right.
On part of this report card, we talk about like there's the most important things for each section, and then there's some other things that are also equally important. So
Right.
knowing your value is sticking to those ones that are extra important for you with the protections, and then kind of giving up on a few of the other ones if you need to here and there.
Yep. Before we go on, I want to talk, I want to make sure that people get a chance to get to you. Um, your books behind you are color coded. They're
Yes,
organized by
rainbow
color.
order. Yes.
And I appreciate that.
My
That's
son does not think it's the correct order for books. I think it's the correct order. So yeah.
well, let's take a look here. Let's see this out. So if I look back, no, so red, orange, yellow. It's a rainbow, Roy G.
Yeah.
Biv
There's,
ish.
there's a little green over there. Yeah.
Yeah, 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 yeah. No, that's the way it should be done. He's thinking subjects and authors and
Yeah,
alphabetization
totally.
and
We have
lines.
our brains work differently, yes. But thank you. I appreciate
No,
it.
I think that's fabulous. A reminder to everybody, it is matchstick.legal. We'll put a link to this report card in our post as well, and then we'll encourage you to take a look around. But take advantage of this report card and get to know Matchstick. And Jen, we're definitely going to bring you back for other issues and topics. But this is a good way for us to kick off. And as always, thank you so much for supporting the Indie Agency News mission. And
yeah, absolutely. It's a fantastic community, and like the report cards there, if you guys want it, a free service, you can look at the website. We've got a ton of thought leadership and blog articles. Just peruse, take the information, use as you like. So,
and we're going to share more of that stuff out. So thank you for that, and thank you for being such a great attorney.
Yeah, likewise. I appreciate working with you, Doug. Thank you very much.
All right, Jen, thanks so much.